Hello everyone, thank you for joining me today. My name is Mingxiang Xin and I'm a patent attorney from SPTL. Today I am very pleased to share with you some key insights into the latest challenges and practice of patent invalidation proceedings in China, which I think is a topic of growing importance and interest for international patent right holders and petitioners of invalidation requests. The landscape of patent invalidation in China has evolved significantly in recent years, with updated guidelines, shifting procedural emphasis, and non-judicial interpretations. Understanding these changes is crucial for anyone involved in patent litigation, portfolio management, or freedom to operate analysis in one of the world's largest and most dynamic patent jurisdictions. My presentation today would be divided into four main parts. I would first like to have a brief overview of the invalidation proceedings in China. Then I would focus on the two main key revisions in the guideline for examination relating to invalidation proceedings, which first involves eligibility of the petitioner, and with a focus on recent stricter examination requirements, and secondly relates to the so-called principle of judicata and its expanded interpretation under revised guidelines. Lastly, I would present case studies illustrating practical strategies and challenges. Now let's begin with the first part. In China, the patent invalidation proceeding is an administrative procedure handled by the CNIPA. It is a critical post-grant mechanism to challenge the validity of an issued patent. Unlike in some jurisdictions, it is separate from, though often parallel to, patent infringement litigation in the courts. The standard process flow is well established but has specific timelines that require careful attention. An invalidation petitioner files a request with the CNIPA first at the beginning. Upon acceptance, the patentee receives notice and the transferred request documents. Both parties will then engage with written document exchanges. The petitioner may supplement grounds and evidence within 1 month, and the patentee submits observations with a specified period. The key feature is the oral hearing, which is a common and substantive part of the process, where the panel of examiners actively engages with both parties' arguments. And finally, a written decision will be issued. A critical point to note is that the Chinese courts hearing patent infringement cases are not necessarily required to suspend the litigation proceedings before the outcome of an invalidation challenge at the CNIPA. Nor will administrative proceedings be necessarily suspended due to the pending invalidation request. This means an alleged infringer may face a court judgment or administrative junction before obtaining an invalidity decision of the target patent, adding a layer of complexity and risk to concurrent disputes. However, it is always an option for the defendant to file an invalidation request and ask the court or bureau to suspend the infringement case. Now let's move to some statistics. This slide shows the result of patent invalidation from 2019 to 2022. As can be seen that there are more utility model patent rights invalidated than invention patents, especially the numbers that are completely invalidated. According to our experience, the rate of winning in invalidation process related with foreign entities is between 50 to 60%. In addition, it is also worth mentioning that more and more domestic companies will conduct FTO nowadays, and they will normally initiate invalidation requests if some patents are identified as high risk. According to our recent practice worldwide, it is more likely to successfully invalidate a patent right in China than in other jurisdictions with the same ground and or likely evidences. With the general proceedings in mind, I would now like to summarize this part with the highlights of invalidation in China. One of the most attractive features of China's invalidation system is its efficiency. As an administrative proceeding, the rules of evidence and procedure differ from civil court litigation. From the filing of a request to the issuance of a decision of the invalidation, the entire process typically takes around between 5 to 8 months. This is remarkably fast compared to many other major jurisdictions. Furthermore, the proceeding is cost-effective. The official fees for filing the request are considerably lower than comparable procedures elsewhere. This accessibility has also led to certain strategic behaviors, which I will discuss later. Beyond the speed and the cost, there are also some operational highlights. One of them is prior art document search. The invalidation proceedings relies heavily on prior art evidences. While international patent families and non-patent literature in other languages could also be used, Chinese patents, utility models, and academic publications offers an extensive pool of prior art documents that may be useful for invalidation purposes. A comprehensive, China-focused prior art search is therefore not just beneficial, but often essential for a successful invalidation result. In summary, the Chinese invalidation system offers a swift, relatively inexpensive avenue to challenge patent validity, but it also demands a localized strategy, particularly regarding evidence. Now let's continue with the part 2, which relates to the new revisions of the guideline regarding the eligibility of the petitioner. It is actually a topic that has gained substantially attention recently. That is, who is eligible to file an invalidation request? Traditionally, the basic requirement was very straightforward, which is any entity or individual eligible to institute a civil action could file a request. There was minimal scrutiny at the filing stage regarding the petitioner's underlying motive or relationship to the patent. However, practice is now changing. The revised patent examination guidelines, which will take effect on January the 1st, 2026, introduces a newly emphasized requirement, the true declaration of will of the petitioner. Why is this change in the requirement? It aims to curb the abuse of the system through strawman petitioners, which means individuals or entities who file invalidation requests on behalf of an undisclosed interested third party. This practice obscured the real parties in interest and could be used for harassment or to circumvent procedural rules. Actually, recent practice of the CNIPA has already been in compliance with the latest revisions. Under the current practice, the CNIPA would not automatically investigate the petitioner's genuine intention upon receipt of an invalidation request. The burden will fall onto the patentee. If a patentee suspects a strawman petitioner, they can submit observations and request to the panel to investigate. The panel may then initiate a check, typically by requesting the petitioner to confirm its genuine intention via a notarized statement or by conducting direct inquiry during the oral hearing, sometimes via video call, to assess the petitioner's understanding of the case. The key takeaway on this slide may be that the CNIPA is now actively aware of and is taking active steps against the abuse of strawman petitioners. This represents a shift towards greater transparency and good faith in proceedings. Okay, let's move on, and here are some strategic considerations on petitioner eligibility in invalidation requests. At the filing of an invalidation request, often involved is a calculated choice between filing in the name of a company or in the name of an unrelated individual, sometimes referred to as a strawman. Let's break down the benefits and the significant risks associated with these choices. First, let's consider the benefits of filing the request in the name of a company. There are clear strategic advantages to having a legally recognized corporate entity as the official petitioner. Panel at the CNIPA tends to view a request filed by a company, particularly one company with a clear commercial presence in the relevant technology field, as more substantive and credible. This is especially true when the invalidation request is directly linked to an ongoing commercial conflict, such as a patent infringement lawsuit, a licensing negotiation, or a market competition dispute. The panel understands that a company has identifiable legal interests and resources at stake. This perception can, at a subtle level, frame the entire proceeding as a legitimate business dispute. Sometimes, using a specific corporate entity is not just beneficial, but also necessary to achieve a particular legal objective. The most common example is for the purpose of suspending a patent infringement dispute. According to Chinese patent law and relevant regulations, if an alleged infringer files an invalidation request and then requests a suspension of the parallel infringement proceedings, the court or administrative enforcement authorities are more likely to grant that suspension request if the petitioner in the invalidation case is the same entity as the defendant in the infringement case. Now, filing in the name of an unrelated third party, the strawman, would typically not support such a suspension request, which will undermine a key defensive strategy. Now let's turn to some tips for any petitioner who are still considering filing a request by using a strawman. Given the CNIPA's heightened focus on the true declaration of will, this approach carries substantial procedural risk. Before proceeding, you must critically evaluate what are the intended benefits of using a strawman. Is it to maintain anonymity in the market? Is it to avoid direct confrontation with a powerful patentee? Once you identify those perceived benefits, you must balance them against the significant and growing risks. These risks include the potential for the request to be rejected at the eligibility examination stage, the imposition of burdensome notarization requirements, and the possibility of public exposure to the strategy during an oral hearing inquiry. If you decide to proceed with a strawman, it may no longer be enough for the strawman to simply sign a form. You must ensure this individual is fully prepared and available and understands their role for the entire duration of the proceeding. They shall be ready to respond to inquiries from the CNIPA, which could come via official letters or during a live video inquiry at the oral hearing. The panel may ask direct questions about their profession, their interest in the technology, their understanding of the prior art, and their reasons for filing the invalidation request. In this case, inconsistencies in information provided, a lack of necessary knowledge, or unwillingness to participate of the strawman might be fatal to the case. It is thus advisable that we shall not wait for the panel or the patentee to challenge the petitioner's eligibility. We shall prepare the evidentiary groundwork for genuine intention from the very beginning, which involves preparing a detailed, legalized, sound, notarized statements and conducting mock inquiries, for example. On the other hand, patentees should be vigilant too. If you receive a request from an individual petitioner with no apparent connection to your technology or industry field, it may better be prudent to investigate and consider challenging their eligibility early in the process. In summary of this part, as CNIPA is now aware of and taking action against the abuse of strawman in invalidation requests, both parties involved in the invalidation proceedings shall pay more attention to the examination on true intention, especially when the request is filed by an individual petitioner. Okay, this is the end of part 2, and now we are at the third pillar of today's discussion, which is the principle of judicata in invalidation proceedings. This slide shows the current regulation. The existing rule in the guideline related to the judicata principle is mirrored in the patent law regulations, which states that after a decision of an invalidation request is made, any new request for the same patent based on the same causes and evidence will not be accepted. According to the revised guideline effective on January the 1st, however, a critical phrase is added, which is based on the same or substantially the same causes and evidence. Such an expansion in the word same can be seen as a formal elaboration of the meaning and is intended to close loopholes and reduce redundant requests. Let's say that such a revision is substantially in line with the current practice already, but is a clear signal that the CNIPA would be more likely and would be tend to apply this principle in the near future. Well, here are some anticipated possible practice of this principle of judicata. The key question is, what constitutes substantially the same, right? While final interpretation will come from later practices, we can make some anticipations on several scenarios based on current practice. The first one is new patent documents from the same family. For example, by submitting a U.S. continuation patent that discloses essentially the same technical contents as the previously cited U.S. parent patent would likely be considered as substantially the same in the evidence. And the second one is that the concerned content is being substantially the same. Let's say, even if in the form of the evidence, maybe there's difference in the form of the evidence. For example, the first one is a product manual, and the second one is a catalog page for the same product. If the relevant technical disclosure of them is identical, then the evidences may be deemed as substantially the same. The third one is relating to novelty and inventiveness grounds using the same evidence. For example, if a piece of evidence X was previously used to prove a claim that lacks inventiveness, a subsequent request using the same evidence X to argue the claim lacks novelty might be considered substantially the same grounds. The last one is clarity grounds on different claims. The arguments relate to unclarity of the same portion of description, but the same is used to invalidate Claim 1 in the first request and then to invalidate Claim 2 in the second request. Then the latter one may fall under this principle and not be considered. In brief, this tightening of res judicata underscores the need for petitioners to present their best and most comprehensive case in the first instance. Strategic testing of arguments through sequential requests is becoming riskier and is more likely to be rejected outright. With the discussion above of the two key changes in the examination of invalidation requests, in this part, in order to have a clearer picture of the changes, let's examine two illustrative cases. The case study 1 relates to a global company's defensive strategy. Company A is a local manufacturer and attended a trade show abroad. And the company A received warning letters and later faced against infringement lawsuits from a foreign patent holder based on overseas patents. The challenge is that the opposition periods for these foreign patents had expired, which limits our options to invalidate those patents in foreign jurisdictions. Company A then investigated and found that corresponding Chinese family patents are also valid in China. It then proactively filed a validation request against these Chinese patents at the CNIPA. The goal of this invalidation was not solely to invalidate the patent, but also to create leverage. By demonstrating the vulnerability of the patent holder's Chinese rights, Company A is aiming at persuading the patentee to negotiate a global settlement or agree to claim limitations that would resolve the infringement concerns. This case highlights how China's efficient invalidation system can be a powerful tool in global IP dispute strategy, even if the initial conflict arises overseas. Case 2 relates to challenging a typical strawman petitioner. The situation is that a patentee found itself facing multiple invalidation requests against its portfolio. All requests were filed by the same individual petitioner. Preliminary investigation shows that this petitioner was rather elderly and had filed over a dozen invalidation requests against various unrelated patents in recent years that belong to a pattern that is inconsistent with a genuine and independent interest in specific technologies. The patentee then formally shared this information with CNIPA, the panel, and requested investigation into the petitioner's genuine intention. CNIPA's response is rather serious. The panel took the request rather seriously. They not only required the petitioner's agency to provide a notarized declaration of true will, but also conducted a direct video inquiry during the oral hearing. The petitioner was asked to explain their interest and understanding of the technology in question, while the final decision on the patent's validity proceeded on technological merits. The investigation into the petitioner's eligibility sent a clear message. It demonstrated the CNIPA's willingness to employ its tools, which is notarization and direct examination, at site, to uphold the integrity of the proceeding. Some small hints from the two cases is as follows, which is we shall consider the strategic context of a dispute and remain alert to procedural irregularities that could signal an abuse of the system. Now let's end with conclusion and takeaways of today's discussion. To conclude, let's recap the core features and strategic implications of China's patent invalidation practice. It is fast and frugal. The 5 to 8 month timeline and the low official fees make it an accessible and potent tool. However, courts may not wait for its outcome. Petitioner scrutiny is increasing. The true intention requirement is moving from theory to practice. Strawman petitioners face a greater risk of exposure and procedural hurdles. Judicata principle is elevating too. Substantially the same standard will limit sequential piecemeal challenges, which will place a premium on a well-prepared, comprehensive first attack. The 2 case studies showed that invalidation action in China can be a key move in a worldwide IP conflict, and procedural rules are now being actively enforced to ensure a fair play. Last but not least, here are some recommendations for your reference. For those considering challenging a valid patent with invalidation request, it is recommendable to conduct a prior art search in China first and then assemble your strongest case upfront. For patent owners, we shall be aware of the new regulations regarding petitioner eligibility and judicata principle, and use them to defend against abusive or repetitive challenges. For both parties involving in the invalidation proceedings, we shall pay close attention to the implementation of the 2026 revised guidelines, as this revision may further define the boundaries of acceptable practice and in this dynamically changing field. Okay, that is the end of my presentation today. Thank you for your attention, and please feel free to contact us if you have any further questions. Thank you. Bye-bye.